Good afternoon. Welcome to the Human Results Podcast. As always, we have the Managing Director of Human Results, Mr. Alasdair Hobbs. Good afternoon, Alasdair. How are you?
Yeah, afternoon, Ben. Very well, thanks.
Good, good. Keeping warm. It's very nice to be talking about warm.
It's nippy. It is nippy this morning, but nippy all week. But that's good. We're not going anywhere.
No. Well, this is why we've brought on the lady we have today, because we want that jet stream pushed back up so we can have a bit of that European warm air, isn't it? So without further ado, we'll introduce today's guest. There's no doubt that recently the legal speak between the European Union and the UK has changed. Every agreement needs looking at, and that also involves legal experts from the European Union. And today we do have one, well known to Alasdair and will become well known to the British audience. Anca Thomson, how are you?
Very well, thank you very much for having me.
No problem. I'm guessing it's warmer down in the Dordogne than it is in the UK at the moment.
Yes, slightly warmer. Still very wet though.
Okay, that's not made us feel any better, but that's okay. It's about -5 here. Anca has a whole list of expertises, but rather than me go through, I'm going to ask Alasdair to run through who Anca is and how he knows Anca.
Anca and I have worked together for much of the last 7 years in those areas of business which are not considered reserved legal business, but Anca's an extremely experienced and well-qualified company commercial lawyer and has been a big help for clients of mine on all manner of issues. Anca's, out of necessity, has also become something of an expert on cross-border jurisdictional issues and Brexit. So it's a useful opportunity to have a chat about how things are over the last 6 weeks or so. It's not exactly dominated the press like it did pre-pandemic or indeed pre-Christmas even, but quietly in the background, there have been big changes and there are winners and there are losers. And I thought it might be useful for over the course of this year to keep abreast of those changes and how they're affecting people.
So we'll start with manufacturing and goods, Anca. The trade and cooperation agreement between the EU and the UK was agreed and signed on Christmas Eve. How has it been received?
I think it's been received initially very well, with a sigh of relief because we left it very late to agree things. But I think since then, as we knew already, but we have seen, people have realized that it lacks a lot of substantial agreements, that quite a few of the industries are not covered by it. It is more a question of trying to interpret it in its narrow format rather than accept it as a type of legislative agreement from which you can actually interpret any situation given with a client that you have. Yes, a good principle to start with, because we've seen that EU and UK can agree on something, but it needs to develop further as we move along in the next year to touch upon and agree in all sorts of other industries. Manufacturing, as we've seen on the news, I think most manufacturers have actually had to prepare very, very hard for any developments. The import and export has been touched upon profusely. There are many changes in relation to compliance, import and export licenses, the tariffs, the labeling of goods, which is very important, potential new VAT rules that are going to be implemented, I'm pretty sure. Customs procedures, we've seen the complaints about the new custom forms and how difficult that is to be understood and processed, even though I think the UK government now have recruited more and more custom people in order to actually be able to help with this. New approvals for medical devices, the marking, which has the CE, the Conformité Européenne as we knew it, has been replaced by UCCA, which is the UK conformity assessed. So there are many, many modifications and implementations to be brought in, but things are developing. It's not easy. I'll be very honest with you. It is not an easy, straightforward process, but we have to deal with it.
Version 1.2 and 1.3 aren't too far away, is what you're saying then, Anca, isn't it?
Yes. Yes.
Yes. And how long do you expect this to settle down? How long a settling down period do you expect for the agreement before we actually get to the final agreement that we're all going to work off the basis of for many years to come?
I think each industry is going to develop at its own rhythm. One of the most important things that has influenced our practice and the clients that we most deal with is services. And services has not been part of this particular agreement that has been signed with EU. Is still very much in discussion, is still very much up in the air. Let's not forget that UK is the 6th largest world economy in its services, and its services sector represent over 70% of its GDP. So it's huge. Financial industry is still one of those very, very important core parts of the UK, not only GDP, but because it's not so much in terms of percentage, but in terms of relevance, in terms of reputation, in terms of income that is generated. Therefore, we really don't know where that is going yet. I know that the passporting regime has now ended. There is a proposal for some form of enhanced equivalent. I think the UK has been more generous to EU than the other way around, which seems to be the line that EU is taking at the moment. But I can't see somehow the city not staying as one of the most reputed prime position on the global financial world, to be honest with you, and as a financial hub. So we'll have to see how that is going to develop. We've got an awful lot of work to do in terms of negotiations. And it's good that they started well, but we don't really know where we are. And I think it's going to take at least 2021 for things to settle.
And we're seeing things occur, aren't we, Alasdair, with things like privacy policy changes and things like that in the UK that are taking effect now?
Well, yes, obviously, GDPR as a European piece of legislation has now effectively come to an end, but the provisions are still very much in place. We've not diverged in that regard. Don't expect to see any significance there. The UK is a first world country and had a huge influence on the whole GDPR piece. So at the moment, purely practically, employers and indeed companies generally who have data, cloud-based data, they just need to know where that data is. And obviously it should be in the UK. Clients need to know. Certainly in the reality, in practice, if you're in a subscription service of some sort, you know, the likelihood is that the cloud-based data retention was possibly in 2 different jurisdictions, but in the UK as well. So in practice, almost certainly, like with our own HR platform, you know, that our clients' data is stored on servers in the UK. Prior to that, it was in the UK and in Europe. So there will be subtle changes to consider to your standard paperwork around privacy notices, for example, explaining what data you will hold on them and where it's held. We are getting round to ensuring that clients update where necessary. But at the moment, there's been no huge drama. As I say, we're very much locked into the issue of the pandemic, and there's a lot more practical considerations at the moment that we will see divergence over the course of the year and beyond. It's not going to be change for change's sake. I mean, let's see what the government's report on regulation is. But I think the fearmongers that talk about employee rights being hugely hampered or diminished, I don't think they should be too alarmed just yet. I don't see that there's no appetite for that. But I think it'll be interesting to see how tribunals and courts interpret the EU-driven legislation that's now been incorporated fully. We will see some common law interpretation that might be deemed to be a divergence over time. But I don't see any dramatic revolution anytime soon. Certainly not this year. I think the government and HMRC and others have got a lot on their plate. We've still got IR35 to consider in April. Again, IR35 is nothing new, but for end users of contractors' services, the significance will be that it will be for them to police and decide whether or not somebody's an employee or genuinely self-employed, and they'll be picking up the tab if they get it wrong. That's first and foremost. Vaccinating your staff, will you or will you not be insisting on it that your staff are vaccinated? That's obviously another practical consideration that's more on people's agenda and radar at the moment going forward. So I'm not ready to do any kind of post-Brexit speculation at the moment. We'll address those changes as they occur.
Back to what you always say, Alasdair, you'd rather be the person that reads up on a case than be the test case itself.
Oh, absolutely, Ben. Very much so. Always better to learn from other people's mistakes.
Anca, you are an intellectual property expert. How are things? Obviously, we spoke about data. How are things on the intellectual property side in the EU?
I think everyone sort of knows, and if they don't know, they found out on the 1st of January 2021, any EU registered trademark will cease to cover the UK and vice versa. So there have been implications. This also, any UK qualified lawyer cannot actually represent anymore anyone that wants to register their trademark in EU. Will have to always refer that to our colleagues in EU, which is unfortunately not good, but anyway, it is what it is. We haven't got much choice about that. For the pending EU trademarks that were not registered from the 1st of January in UK, then there is at the moment a 9-month period in which the owners will be able to apply to the UK to register as these trademarks. And this is what's happening at the moment. We've seen quite a few applications in that sense. There haven't been many other amendments to this. I think as we progress and jurisprudence develops and new cases sort of come, we are going to see developments. Where I have particularly, if I may continue, sighed a breath of relief is in relation to companies and Companies Act 2006, which actually hasn't been affected in any way in relation post-Brexit. And that's because UK is domestic law. Companies very much operate within that system. In any case, the laws are really good. The act is pretty flexible. We know hopefully what we are doing, and that's it. The problems occur when we have either EU companies that establish subsidiaries in UK and the other way around. There is a little bit more registration to be had. I think the Companies House are tightening those rules. We have to provide far more information now for EU companies that actually establish subsidiaries in UK. Things like where the company is incorporated, where it's registered. Always we have to pay attention now. We had to do that before as well. We have to, for example, a UK company that is a limited liability company and it operates within UK will have to be managed from UK. HMRC always looked at that in any case, but now I think we'll have to be even more careful. My concern is in relation to UK companies that actually open a subsidiary in EU now, and before, for example, if it was a limited liability UK company that had a subsidiary in a EU country, it was an automatic recognition that that will have a limited liability status as well. So shareholders from UK, for example, would actually register something there, and because it was a limited liability company that they were operated through in UK, would be having a limited liability status in Europe as well. Now we have to make sure on cross-border things and that we check with local council the status of that particular subsidiary, because it will not be automatically recognized. So we can find the shareholders, and this is obviously a hypothetical thing, but it can happen that they think they've got protection from a limited liability company, but they don't necessarily have so in that particular EU jurisdictions, which I think, if I'm not wrong in this, in my thinking, Alasdair, it's a very serious consequence, because they might have an unlimited liability. So it's good to pay attention and make sure that you check it. But otherwise, M&A work is very either domestic or cross-border, is always governed by private contractual agreements. Therefore, nothing has changed. There are one or two directives that might influence that now will not apply anymore. I would say that's not necessarily a bad thing, because it will give the transaction a little bit more fluidity. Otherwise, not many have changed. Where we have to again be very careful is in case we've got competition issues that are applicable. They will continue to apply. So check the competition issues, get the necessary clearances, etc., etc.
And obviously, we've looked at the companies. But obviously, a company's only as good as employees and employment. How are things changed in regards to that, Anca?
Well, I think you've got the expert there who would be able to tell you much better than I do. But I think nothing has changed. Most of the directives and the EU legislation has already, unless Alasdair is going to say no, of course, but as far as I know, has been already implemented within UK legislation that will continue. Things like TUPE, for example, they are still very much applicable. They are there. Whether that will develop, I can't see a country like UK to lower its rules and regulation in relation to the protection of employees somehow.
No, that's right, Anca. I think the point is, whichever side of the fence you were with your voting, the fact is we're in a global economy, and if you're going to have free trade agreements, you can't undercut other people's markets and expect to have tariff-free entrance to those markets. So I think areas like labour law will always be front and centre of many of these free trade agreements. So we're not going to see dramatic change. Nothing that could create an uncompetitive advantage or a competitive advantage. So I don't think we'll see anything dramatic there. So no, in terms of at the moment, any EU residents or who've been resident in the UK since prior to the end of the year, they need to make sure they get their settled status registered by June. But most employers who've got EU nationals working for them will have been proactively helping them with that if they needed any. And as I understand it, actually prior to the end of the year, there's been a continued quite strong migration of workers to the UK. People still want to come here. Be interesting to see how the point system works and whether that results in a slowdown of any great significance. We're an aging society. We still need plenty of young blood. Tend not to have the big families of old, so we've got to keep going with that. Yeah. Immigration is a necessity. So it'll be interesting to see how, whether there's going to be initiatives that provide additional influx of short-time temporary workers into, whether it's harvest season or any particular seasonal norms, or for certain market sectors that need to recruit more. But fact is, we will continue to welcome migrant workers to these shores, I'm sure.
We will. And I think just to finish off, we are obviously a legal podcast. Courts, dispute resolutions, how are they being implemented, Anca, over the last?
I think from my perspective, one interesting dilemma is there is no established agreement anymore now that UK has left the EU about the implementation of court decisions. So what I have come across in cross-border agreements is the dilemma of, if you have a foreign party, of whether they will, especially from EU, whether they would agree to the agreement being governed by English law and the jurisdiction to be given exclusively to English courts. I say English because I tend to work more with English and Welsh laws than Scottish laws. I'm not a Scottish qualified lawyer. Now, I think before you had that recognition. So if an English court would actually award a decision or make a decision, then on a EU party that has got is registered in EU and has got all its assets in EU, you can implement it. Now we can't anymore at the moment. Why I'm saying at the moment is because by coming out of European Union, we've come out of the Lugano Convention, and we have to go back to the Hague rules that are slightly less easy to interpret and longer to actually access. I must mention that UK has actually applied at the third party now to join last year the Lugano Convention. So I'm hoping that this year this will clarify, but it's always in the back of my mind what sort of governing law and jurisdiction clause I put into that agreement when I have this element of cross-border parties with European Union client or opposite party. I think it will solve itself out. You always have to present the option of arbitration, which is much better instituted, and then you have that as well. But that's a little bit of a dilemma at the moment.
And I'm sure we'll revisit in this podcast. Just to finish off, Anca, it is EU and the United Kingdom. We're certainly not splitting down to England, Scotland, Ireland and Wales after the Six Nations the weekend. Otherwise, Alasdair will be on us for another half hour telling me how good Wales were.
Yeah, and Scotland. Wales weren't good. We just got the result. Scotland were good and got the result. Yeah.
Brilliant. Now, Anca, your expertise will bring much benefit to the UK market. We know that over time. And this won't be the last time you appear on the podcast. Thank you for coming to see me in Alasdair today. Alasdair, as always, thank you very much.
Thank you, Ben.
Thank you. Lovely to see you, and thanks for having me.